Won't matter if you have transportation, you'll be in custody to get the help that you need. Either you take advantage of that or you don't. So you're going to get all the tools for both mental health issues, drug use issues, self-medicating, all of that. And when you get out of SafeP, you'll be on the high medium caseload in order to do whatever it is to follow up with spinal tap, follow up with drug treatment. And at that point, if you don't do it, there's no arguments that your attorney can make that would convince me that you should get another chance. This is your chance. Do you understand?
Yes, ma'am.
And this is cause number 24, DCCR 0766. Ms. Lewis was granted probation for aggravated assault with a deadly weapon back in September of 2024. This is a motion to revoke. She pled true to counts 1, 2, 3, and 4. I've received an updated pre-sentence report. Have you both had an opportunity to review that report?
We have your state has to.
And this was unagreed, correct?
Correct. Yes, Your Honor.
All right, Mr. Parker, you may proceed.
Your Honor, just first like to point out there, she has no new cases. Part of her issue, I mean, she's not reported. She's claimed some mental issues, which although the probation department didn't have knowledge of, I think they've confirmed that by talking to the infirmary, the jail. And I believe she did have issues. She was in a wreck, and she's, I mean, I can tell you, she's acknowledged to me that she's told me the right things, which was promising, that she didn't go to probation because she was in a wreck and she was uncomfortable and it's hard to her. She also acknowledges, you know, I should have gone. I should have had better contact with my probation officer and done what I'm supposed to do. She's very convincing to me that if she's given the opportunity, she's taking the medications that she needs to take, and that she will be able to complete her probation. I'm asking the court to put her on a high medium caseload and see if she does what she says she can do. If she's on her medication, and we can see if she actually will report. I mean, it won't take long to see if she reports and she starts doing her community service. You know, they're administrative violations pretty much, and I'm asking the court to give her another chance. And do you want to address the court? Hold on. And she'd like to address the court, Judge.
Go ahead.
I would like for another chance, and I promise that I'll make sure that I do all my things that I'm supposed to do for my probation.
Explain to her what you told me about why you didn't do what you were supposed to do the first time.
I got in a car accident, but you know, like I say, I'm not using it as an excuse. But I was out on transportation and stuff like that, and I couldn't really make it to where I was supposed to make it. And I've been taking my medicine. I've been doing everything that I'm supposed to. And I promise that I'll continue doing everything that I'm supposed to do to complete my probation.
And you told me what should you have done when you weren't going? You should have done what?
Should have reported.
And you should have communicated with them.
I should have communicated, especially with my probation officer.
Mr. Coleman.
I don't have much to offer, Judge. Same things and making representations that they're easy to do and easy to say. But it's the deeds, the actions of the defendant that matter. And Judge, she's essentially done nothing on probation. If it's a mental health issue, she's got to take the first step, Judge. She has failed to enroll in spinal tap to get those mental health, whatever mental health issues, if any, addressed. You can't do this probation for her, Judge. And the definition of insanity is doing the same thing over and over and expecting a different result. Putting her back on probation, given the fact that she's just utterly failed, would be, in my opinion, doing insanity, doing the same thing, expecting a different result. She's just not going to. Her past behavior has indicated she's just not going to be successful at probation.
Your Honor, I don't think that's fair representation, because obviously the probation department didn't know she had a mental health issue. They acknowledged that. And when they do know that, they take steps to help these people that have problems. And she did take steps to get on medication, and she has improved by being on medication. I think with the assistance and the knowledge that the probation department has, that she has a mental health issue, and she actually is taking medication for these problems, it may help her. She may have a better chance.
So I'm looking back at the original pre-sentence report from 2024.
Mm-hmm.
And so it was noted in that pre-sentence report in 2024 that she had an appointment with Spindletop for a specific day that she failed to show for during the pre-sentence report, that time period. So it's not a surprise to anyone that there was some issues back then that weren't followed through with to go to Spindletop. That was ordered at it was in the order back then for her to be assessed for services at Spindletop, which never happened. So here's the thing. Here's where I am. I don't disagree that, I mean, Miss Lewis has really no criminal history. This is the only case. There's clearly some mental health issues as well as drug issues. But I'm not going to just say, okay, go out and do Spindletop, because we've already said that a couple of times. So what I am going to do, and this is your opportunity to take advantage of this, Ms. Lewis, is I'm going to find that you entered your pleas of true to counts 1 through 4 freely and voluntarily. I'm going to find those counts true. I'm going to find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to continue you on probation, but I'm going to order that you enter and successfully complete the special needs safety program. That will address all of these problems. If you say you want and need help, so this was not an agreement. You do have some rights to appeal. I'm handing you that written certification. I hope you take advantage of this and get everything you need because you'll be given that opportunity. Okay.
Yes, ma'am.
All right. Good luck to you.
Thanks, Judge.
Good morning. You're Leroy Harris.
Yes, ma'am.
And this is cause numbers 24 DCCR 0404. Mr. Harris is charged with murder, and 19 31482 charged with possession of a controlled substance. What is the announcement?
We have a tentative plea agreement, but it needs to go through the channels before, so we just need whatever the state needs.
And Judge, the court has been patient with us with regard to his Harris County case. That was obviously resolved. Not quite what we had anticipated that resolution would be with respect to also taking care of this case. But we did bring him back. Those cases are pending. I extended a somewhat of an offer to Mr. Burbank with the understanding I needed to know some specific information before I took it above my head, which he's now informed me that would be an equitable resolution. So I just need to get a little bit of approval for that, and hopefully we can wrap it up just at the next plea setting. I mean, maybe not a definite to plea, but we're close.
Okay, let's reset it 2 weeks. All right, we'll reset your case 2 weeks. Kavon Saunier.
I made a mistake on this. They've been diagnosed as a first. I think I put it out as a second.
Okay. Sorry, Mr. Nicholas.
Good morning. What was that? The count on the objection, the second, is having the divided. I don't know.
No, go back.
Good morning. Are you Kavon Saunier?
Yes, ma'am.
And Mr. Saunier, you're charged in cause number 25 DCCR 1530 with a first-degree felony offense of aggravated assault with a family member. And that's from September 28th of 2025. And what that means is that if you go to trial and you're found guilty, the range of punishment would be a minimum 5 years up to 99 years or life in prison. Do you understand? And I have here on the tablet a plea bargain rejection that you've signed with Mr. Burbank. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty or a 20-year term in prison. You have every right to reject that offer and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter a plea of guilty. And do you understand all of that? And do you want to reject that offer and have your case set for trial? And I did make the adjustment on the plea bargain rejection from a second to a first that he's been admonished. Is there any reason to believe that that offer would change?
No, Your Honor. I know there's some questions with the complainant that he's aware of because he talks to her on the phone all the time, but the state's offers don't change.
Okay. So you're talking to her on the phone from jail? Okay, so I'm ordering today that you are not allowed to have any contact or communication at all with Delaney, is it Saunce? Okay, you cannot talk to her. You can't call her, you can't send her letters, you can't send messages through anyone else, period. Do you understand? If you're caught doing that, things are just gonna get worse, okay? All that information will be information that a jury can hear, or I can hear, Mr. Nichols will hear it. So I'm ordering you now that you are not allowed to do that. If we catch you doing that at the jail, I can order that you have no telephone and none of those things. Do you understand? Okay, all right, go back with the bailiff, do your case set for trial.
Thank you, Your Honor.
Thank you, Mr. Burbank.
That's it. I think we had a Robert Griffin. He was placed in federal custody this past week. He may be off without.
Yeah.
I have excused.
Yes, sir.
until 1 o'clock.
Yes, sir.
Is it 1 o'clock? One for
One. Mr. Eckhart, you have Timothy Bessard.
I do, yes.
Morning.
Morning, Judge. You're not gonna say good morning?
Already did.
He's already been up here.
My first one's good for me.
He's always got a show off.
You're calling for you.
Very far.
Good morning. Are you Timothy Bessard?
Yes, ma'am.
And this is cause number 26 DCCR 0276. Mr. Bessard is charged with aggravated assault with a deadly weapon. And 26 DCCR 0600 charged with murder. And what is the announcement?
Judge, I talked to the parent this morning and we have discovery, we have media. However, we are still waiting on a number of different lab reports. For sure the murder, and I think maybe also the aggravated assault.
Okay.
Specifically DNA.
Okay.
And so I think we're kind of at a spot where we need to kind of stall a little bit until we get those reports in and get the files in.
That's correct, Judge. We're working on some things.
Okay. Any idea of,
I don't know, but I'll look into it and see if they can step it up or anything.
okay, if you'll, obviously since he's in custody, if you'll take a look at that, we'll reset it so that you guys can work on getting that DNA, those results back, and then we'll, see where we are. We'll do about 45 days. But if you'll check on it, see if they can kind of bump it up if possible, that'd be great.
I will, Your Honor.
Thank you. All right, you
You
go
have a
back with
blessed day.
bailiff.
Thank you, ma'am.
See, Mr. Eckhart, you have Robert Trahan, 3 cases. Let's get, well, he's got 2. Dalton Batiste also, or just switch on whichever.
Judge, I found another thing in that case, if I'm not mistaken. I don't know if the court is finding my certificate on it. I think there was an accumulation.
On Trahan?
It's in the enhancement.
Yeah, I'll do Trahan real quick, and then Batiste as soon as that one's done. All right, sir, you Robert Trahan?
Is not.
And Mr. Trahan's cases are set, for trial to begin with jury selection next Monday. There's 3 cases. We've got 25 DCCR 1094 charged with unauthorized use of a vehicle. 25 DCCR 1317 possession of a controlled substance. And 25 DCCR 1536 charged with evading arrest or detention with the use of a vehicle. And what is everyone's announcement?
You first.
State's ready.
We're ready. Judge, I do have, I was special set in orange on a bond case. So I don't know how you want to handle that, but I was special set before this case was set.
Is there a protection order or it was just a setting? But they're on bond?
Yes,
In whose court?
Townsend.
Talk to them and we'll go from there.
And I
But
have a
if,
pretrial in that court tomorrow. So if whatever happens here, if I know before tomorrow. then
yeah,
I should-
you'll know the number today of your case. And so it looks like, the state, well, Mr. Coleman, which case would the state elect to proceed on?
The evading judge.
All right, so 1536 would be the numbered case. And it looks like the state has filed a notice of intent to introduce extraneous? Is that just for punishment or is it any enhancement?
It's for punishment, Judge. The indictment has already enhanced this case to 25 to 99, if I'm not mistaken.
That's correct.
And the
And it
state's
looks like the previous plea bargain rejection, when we were here in March was for 7-year term. Is that correct?
yes, Judge.
And so, Mr. Trahan, there's only a couple of cases left set for trial, so it's very likely that yours will be close to the top of the list to go to trial next week. I want to make sure that's what you want to do, understanding that if you're found guilty and if those prior convictions are true, that you would be looking at a minimum of 25 years in prison up to 99 years or life.
Yes, ma'am.
Okay, and it looks like the state has also filed a motion to cumulate, which means you've got 3 cases. They're all from different offense dates. And so if you're found guilty on one, then we could go to trial on the next one. If you're found guilty on that one, the state could ask that any sentence you get, if you're found guilty, be stacked on top of each other in all of these cases. Do you understand that as well?
Yes, ma'am.
Yes, sir.
And not to get into the facts of the case, have no doubt Mr. Eckhart has gone over the video with this defendant, but Judge, it's captured on video.
And
Okay.
have you looked at the video?
Yeah, it's a misunderstanding.
Okay, I just want to make sure you've seen it, y'all discussed it, and so we will number the case. I'll number it as soon as docket's over, and we'll let you know so you know what to do about next week as well.
Thank you, Judge.
All right,
Judge.
thank you. You can go back with the bailiff. Mr. Gertz on Dalton Batiste. Jacoby and Dorsey.
Judge, I just got the media on that today. So got the paper discoveries, need to go over the media. and
Okay,
then
let me
we
hold
should-
on, they're getting them.
There's no objection to a reset.
We should be ready to. Very blue on that camera.
Yeah, it turns you guys all into Smurfs. It's blue hair, blue jackets, like even your gray jackets, y'all both look blue.
My gray hair.
Yeah. We noticed it on Mr. Nichols first. His hair was very blue. We made some adjustments and it looked better, but it's kind of back to
You
the,
need a gaffer.
it's because we have these gray made in the USA spotlight cameras that they made us.
I'll
All
go with Gaffer later on.
right, so are you Jacoby and Dorsey? And this is cause number 25 DCCR 1896. Mr. Dorsey is charged with manslaughter. It's my understanding that Mr. Radford was able to receive this morning the media and any videos and things like that. And so what I'm going to do is reset the case for about 30 days. Mr. Radford will be out there to go over all of that with you, and then we'll get an announcement at the next court date now that he has everything, okay? All right, you can go back with the bailiff. Lively Stratton.
Lively Stratton. Any correct. Correct.
Good morning, sir. You're live in Stratton.
Yes, ma'am.
And this is 19-33601. Mr. Stratton is charged with capital murder. And what's the announcement?
Judge, we have gotten, I think, all of the media, but we're having a wrinkle with one of the police reports that's rather lengthy that Ms. Molfino is trying to figure out why it's not transferring over from the old program.
Okay. Other than that, though, everything has
Other than
been,
that, I'm missing about 20 or 30 pages of police report. Other than that, I think we're good.
And what we're doing, Judge, is somewhat equivalent to kind of a reverse manual bait stamp, if that makes any sense. With it converting from workflow to Odyssey, there was all kind of glitches, including the media. We have recreated that from originals at the police department. But maybe that some of it is merged into one another, but myself and intern are going through it this time and just documenting every single page number so I can get that to Mr. Radford and he can tell me which 20 is missing, because just I'm missing 20 out of the 2 red wells I had. It was difficult and I wanted to, of course, have everything, but I think we've probably exhausted all of our discussions regarding the judge and are headed to the trial docket.
so is there any reason to believe that those pages out of that police report would change the position.
I don't know, but I doubt it, but I don't know.
So here's what I want to do. I'm going to give one more reset for an announcement.
Okay.
If the case is going to trial, I want to try it before the end of the year. So we're getting already halfway through the year, so we need to start looking at some dates and what's available if possible for the end of
I'd
the
like
year.
to get a special setting judge. I have some out-of-state witnesses that.
Yeah, no, it's gonna definitely be, I think because it's the nature of it and we'll definitely make sure that when it's set, it will be the case to go. We'll do a
Mm.
protection order if you need it and
Yeah.
things like that. So we'll make sure everybody's available. If you have any other cases that are set that you know are going, that are specially set, kind of maybe start an email with me, you guys, and we can start coming up with a date. Obviously, if something happens before then and it's taken care of, that's one thing, but if we want to start looking for a date, let's go ahead and start looking for that now.
I guess we can, after we get the next reset, we can have a pretrial conference in chambers and get some dates.
Yeah, I mean, just start an email
Okay.
and we'll start it that way. And
Because I have so many family members, I will reach out to them now and kind of take a look. If, obviously with the age of it and the witnesses, et cetera, it's a lot of moving parts.
it
so I'll-
is a
I'll try
lot.
to
So
get
that's
it.
why we need to get it set so that everybody can get everybody here and subpoenaed and we don't, we can't. It's gonna be difficult for everybody to be completely available, but if they know ahead of time and they're under subpoena, then they won't have a choice.
do
So
have
I'd
a-
rather do it that
I
way.
do have a trip planned out of the country for Thanksgiving.
You'll just make sure you have that
I'll send that to.
vacation letter
I
in.
will also.
Okay. All right. So let's just do 30 days. That way you guys can please get the police report. If that changes anything, we'll know then. Otherwise, between now and then, let's start looking at other dates, but we'll have one more announcement
Yes, ma'am.
before trial.
May I be
Okay.
excused?
Yes. Mr. Parker, you have Darius Rigsby. Morning.
Morning.
That's an aggressive.
Well, it wasn't meant to be. I did that to Judge Davis one time. I went back and clapped my folder. He was back there and I didn't know it and it loud. He thought this was have a heart attack.
Good morning. Are you Darius Rigsby?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
You know, Your Honor.
Mr. Rigsby, in cause number 25 DCCR 1089, you're charged with a state jail felony offense of unauthorized use of a vehicle from May 18th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Rigsby is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of unauthorized use of a vehicle. Sentence you in accordance with your agreement to a term of 12 months in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, so you did waive your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with me. All right, good luck to you, sir. Can you go back with the bailiff? Andrew Howard.
Andrew Howard.
Leave no one dismissing the other judge.
Good morning. Are you Andrew Howard?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Well, you're on.
Mr. Howard, in clause number 25, DCCR 0742, you're charged with a state jail felony offense of fraudulent use or possession of identifying information from April 18th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
Objection.
It's admitted. Is there any evidence that Mr. Howard's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of fraudulent use or possession of identifying information. Sentence you in accordance with your agreement to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I will sign a dismissal as part of this agreement in clause number 25, DCCR 0741, and this will also run concurrently with your federal case. Now, as long as,
They've already been sentenced over there, and I think we're good with that.
okay, I just
I've
want to make
explained
sure.
to him that.
Well, I'm going to make sure I explain it too. The federal system does whatever they want. So I'm going to say that this runs concurrently with their case, but that's completely up to them. Okay, so it sounds like it's going to be no problem, but if it's for some reason the federal system says it's not going to run concurrently and you have to do one before the other, there is absolutely nothing I can do about that other than what I say today and what the intention is. Okay.
Yes, ma'am.
So that case is 1:25 CR 56. And as far as I'm concerned, it will run at the same time. Okay. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir.
Thank you, ma'am. That's the one too.
I have no idea about this. It's Michigan. I mean, I'm not representing, usually we don't live in there.
I saw it whenever I get to.
Oh.
Yeah.
I'll get with the misdemeanor prosecutor
Okay.
right now, email them and tell them,
Okay.
part of our agreement was to dismiss
Okay.
any misdemeanors that came out of this transaction.
So everything's taken care of.
Yeah, that'd be.
All right, thank you, sir.
Tommy was a federal prosecutor on the case.
Oh, was he?
That case.
Oh, how funny.
There, told the guy, said, he goes, who's my prosecutor? I said, Tommy called me, goes, hit my federal prosecutor. What?
He does those every now and then. All right, Jason Jones, it's a sentencing.
It's one of those ones.
Sentencing on Jason Jones.
Oh, okay, hold on. What's the name on that one? Album? They're the same, but. You wouldn't know that if you didn't write about what you were.
All right, you're Jason Jones. Okay, so. Mr. Jones has two cases. We've got cause number 26, DCR 0340, which is a new offense. Possession of a controlled substance, a second-degree felony. And then we've got a motion to revoke, which is in cause number 23, DCCR 0390. And the underlying offense in that case is unlawful possession of a firearm by a felon. Looks like we were here Initially, there were pleas of not true, and then in May, we came back on the motion to revoke. He changed his pleas to true to counts 1 and 2. We set a hearing today. The agreement is for a cap of 8 years in each of these cases. Is that correct?
Correct, Judge.
Yes, Your Honor.
Okay, and he already pled guilty on the other one as well.
Yes, Your Honor.
Correct.
Got it. Okay, I have the original pre-sentence report from that unlawful possession of a firearm case, but I also have an updated report that was prepared. And have you all had an opportunity to review that update?
We have, Your Honor.
Yes, Your Honor.
Any additions or corrections?
No, no, we have, Judge.
Not from sticker.
I also have just looks like 3 pages of few incident reports. If you all had an opportunity to review those as well.
Yes, Your Honor.
I have.
All right, Mr. Parker, you may proceed.
Your Honor, we're asking that the court keep him on probation. He wants the opportunity to prove he can complete it. We're asking that you let him serve the ISF track cognitive to make him help better decisions. And also putting in the JCDI program where he's tested regularly. And I mean, then it's, we know whether he's using drugs, but drugs has apparently been the problem on his underlying case. I think he wants to address the court, Judge.
Give me just a second, and then I'll let you do that. I'm printing a PC. Go ahead, Mr. Jones.
Yes, Your Honor. I've had time to reflect on what brought me here before you today. I take full responsibility. And if given a second chance to complete my probation, I just need a chance to prove to you, my family, my children, I can be not a liability to my community, but an asset. I had things going on before I got locked away and started a business, and I'm a single parent. Getting my license and my diploma like you asked me to do. So
Okay.
just asking for another chance to get that done.
In just a second to review this, and then I'll let you go, Mr. Nichols. Mr. Nichols?
Judge, when we entered the pleas of true, it was right before we were about to have a hearing to prove up the new allegation. I'll summarize for the court what that would have shown. Back in June of last year, only about 3 weeks after he started probation, he was detained in an empty lot off of about a block off of Caldern, downtown Beaumont. Not coincidentally, about a block also or 2 away from Henry's place. And what he had been doing was selling crack cocaine. He was one of several individuals in an empty lot that had an active trespass warning on it. And Beaumont police would have testified the reason they went to that lot and detained people that day was because they had received or been informed by several people that had been stopped that week with crack cocaine that they bought it from him. And so when he stopped, he's sitting in a lawn chair in this empty lot where he's not supposed to be, with a plastic grocery bag underneath the chair. And in that chair is about 11 grams of crack cocaine along with synthetic marijuana and I believe actual marijuana. And so he had gotten probation for the charge of unlawful possession of a firearm by a felon. His original felony case was a state jail from Harris County. And then almost as soon as he's put on probation for that, he's in the street selling crack. I don't see how we would keep him on probation. I think 8 years is appropriate. On both these cases, Judge, it's a second degree amount. So the new case that he pled guilty to.
So here's the issue that I have, Mr. Jones. Mr. Parker's argument that there's a drug issue. It's not a drug use issue, it's a drug dealing issue, which is what the underlying case had to do with as well. When you were pulled over for that and you got the case of the unlawful possession of a firearm by a felon, you were found in possession of the Glock 9mm with a chambered round, green marijuana in the center console, another bag in the cup holder, and then another 4 bags and a scale and a second firearm in the car, again chambered with rounds in it. Another magazine under the driver's seat and another magazine in the center console. Now here we are, you get probation for that, and 3 weeks later, you're dealing drugs again. So it's not a matter of I want to do better. It's you literally got probation and 3 weeks later pretty much just thumbed your nose at me and said, I can do what I want and I'm going to go do what I want and sell drugs where I'm not supposed to be. So at this time, I'm going to find and cause number, let's see, what do we have? Hold on. 26 DCCR 0340, find that you entered your plea of guilty freely and voluntarily. Find has sufficient evidence to find you guilty, and at this time find you guilty of the second-degree felony offense of possession of a controlled substance. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 23 DCCR 0390, going to find that you entered your plea to true to count 1 and 2 freely and voluntarily. Find those counts true. At this time, find sufficient evidence to find you guilty of unlawful possession of a firearm by a felon. Find you guilty of that. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm handing you the trial court certification in each of those cases that shows that these were agreements that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, you know this, but I'm required to read it. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition or how long that lasts, you can talk with Mr. All right, you can go back with the bailiff. Justice Lewis, it's a sentencing, Mr. Parker. Hmm.
Yeah, they handcuffed me. Billy said, "Need to do this." Inside, you told me to do it.
Yeah, no. It does not. Thank you.
You got one more case for coming to beat up for me.
See,
It's a, we're only gonna have it's a bond.
it's a bond hearing. Let me see what that one's. I'm just gonna number the case. On Trahan, I'll number the case.
Do you?
It'll be fine by next week.
He went to the hospital now.
Hmm,
He went to the hospital.
yeah, it's Tuesday. Why not set till Monday?
You know where to find me.
Okay. well, then I'm
If
not-
there's some issue that I find out of something that is a major issue where he would not be able to be here for trial, I'll check in before I number the cases.
Same when they call you.
I'll call them and let them know, and talk to them before I number the cases, but I anticipate it'll still be numbered.
Thank you, Judge.
All right, Mr. Parker. On Gabriel Cruz. And Megan, I'll get you next. All right, sir, you Gabriel Cruz?
Yes, ma'am.
And we've got cause numbers 26 DCCR 0373. Mr. Cruz is charged with stalking. Cause number 26 DCCR 0374, charged with violating a protective order. And then cause number 26 DCCR 1060, charged with violating a protective order. And the state has filed a motion asking that I increase the defendant's bond. Hold on, I need to see what the bonds are in each case.
I believe they're
$100,000.
$100,000.
In all three cases?
Well, individual, $100,000 in each individual.
300,000 total.
That's
Yes.
what I need to know.
Yeah.
All right. And has not made bond in any of those. Is that
He-
correct? Or he
He
has?
made bond in the first two, and then he picked up the last new case, and he's in jail on that case, on that. He has not bonded out on that charge.
And the last offense, it looks like has that same
They-
offense date. It was just indicted on, at least on my docket. Let me look at that.
Oh, it's
because-
a different offense state. It's my understanding.
Let me look. Oh, okay. Hold a second. Offense date. It's not, okay. It's not. So the offense date in that last one is March 1st of 2026.
That's right.
So 2 weeks or so after the first alleged offense of violating a protective order. Mr. Coleman, you may proceed.
Yeah, I filed a written motion. I have no doubt the courts reviewed it. I'll just hit the highlights if I may, Judge. The criminal history, I just would ask that the court reevaluate the bonds in light of this defendant's criminal history that includes the conspiracy to possess or distribute cocaine out of the federal court, 2010, unlawful carrying a weapon, Jefferson County, 1994, possession of controlled substance, 1998, an adjudication for possession of marijuana, state jail amount of marijuana, 1998, and a arrest for an aggravated assault that was ultimately dismissed. I think it's still probative in this setting, that history. And in addition to the criminal history, Judge, I'd ask that the court consider the fact that this defendant allegedly committed this new offense of violation of protective order while out on bond for violation of protective order, and it involved the same victim, Judge. I think there are a lot of concerning issues here related to public safety and the safety of the victim in this case. I submit to the court that $100,000 bond on each of these cases is insufficient. I'm proposing a bond of $250,000 in this case. I'd ask the court consider this.
I'm printing a couple of PCs as well. Give me just a second. I'm gonna get some stuff printed out so I can take a look at that. The PC in both of the in all of the cases, so. Okay, I see. So the one of the stalking and protective order is the same.
Day, yes.
PC.
That's right.
Mr. Parker?
Your Honor, I would like to point out that this is, he and his wife are going through a divorce, and it's been nasty. Part of part of the communication or contact with her was because she wanted him to see the child and told him to come get the child, and that's why he was there. I think I can't just, and give me, Judge, I haven't talked to him after he bonded out, so I don't have a whole lot of information, and I just received a new case, so I'm not familiar with all the facts of the new case, so I'm limited to what I know. But a lot of what my communication with him is that he's been contacted by her, and I'm sure she was admonished by Judge Freeze or whoever that to not contact him. But he did say that was one of the reasons she has contacted him to see his child, and then she tries to use that against him, and which is common. We see this a lot of times. There's a divorce going on, and they want to use anything they can. But we're asking that. I mean, he's on there's third-degree felonies, and $100,000 is a high bond. He had some help on the first two cases. I'm not sure if he's going to be able to have that help on these cases, but we're asking to leave the bond the same. $100,000 on with other restrictions, I think is appropriate for these types of cases. If he was out and was intended to hurt her, he could have hurt her. I think, even the facts that Mr. Coleman has raised and some of the stuff is that if he was around her, he could have hurt her if he wanted to. But I think it aligns with what he is telling us that he was, even though he shouldn't have gone over there to see his child, that's more than likely what happened. So we're asking to keep the bond the same, Judge, with other monitoring restrictions.
Killed myself, silly.
Right, so Mr. Cruz, if you have a protective order against you, I know what those say, and I know what the judges and the magistrates tell you about that. No one can give you permission to violate that protective order. And if you guys were just talking about a visitation of your child, I wouldn't have a probable cause that has an allegation that there was 96 text messages, 47 emails, 9 voicemails left stating that you don't care what the protective order says and that you're going to do what you want to do. In addition to pulling in the driveway, that's on February 23rd. 2 weeks later, same thing, numerous calls, and the officers locate you in your vehicle a block away from the house driving past. So it obviously, regardless of whether you have already done anything to hurt her, my job is to make sure that that doesn't happen. And I feel like you have completely disregarded the protective order that was placed on you and the rules that were placed on you down in another court. And so at this time, I'm going to grant the state's motion. I'm going to raise the bond and cause number 26 DCCR 1060, which is the last offense date of March 1st of 2026. I'm going to raise that bond to $250,000. Condition of that bond, if you make it, is that you wear a GPS monitoring device at all times and that you would be on house arrest as well. So you would not be allowed to leave your house. I am going to modify the conditions of your bond in the 2 other cases that you've already made bonds on. Additional bond conditions in those 2 cases, which is 26 DCCR 0373 and 0374, are that you have a GPS monitoring device on at all times and that you are on house arrest. You're not allowed to leave your house without my permission. All right, you can go back with the bailiff. We'll set your case for an announcement.
The bond amount stayed the same in that one?
Yes, I didn't
Okay.
change those bonds amount. I raised the last one
Okay.
and made those modifications.
Okay. I did, hey, I understand. Hey, remember what I said, you're not gonna get for getting big from bond. I was not that. Tell your bonds.
Micah Powell, Ms. Minaldi for Mr. Galmore.
Mr. Gilmore's father written that case to reassess his bond amount. He's requesting a lower amount, he said.
Good morning. Are you Micah Powell?
Yes, ma'am, I am. Good morning.
And this is cause number 25 DCCR 1522. Mr. Powell is charged with burglary of a habitation. Ms. Minaldi is here on behalf of Mr. Galmore, who filed an application for writ seeking reasonable bail. Looks like the bond is currently set at $50,000. Ms. Minaldi, you may proceed.
Judge, just based off of Mr. Galmore's request, it's clear that with his family having an interest in his case and supporting him in that case, he would be here for court settings if he were to be released on bond. He does have the proper means to get to his attorney's office. He does have the proper means to get him to court. He has motivation to show up and handle these cases. He's not a flight risk. He's not at risk of not showing up in that capacity. We're just requesting that he have a bond set that he can afford. I believe Mr. Galmore has requested it be decreased to $5,000 so that he can afford it. It's clear that he cannot afford the current amount of
Let's
$50,000.
put some evidence on with regard to that. Raise your right hand, please, sir, the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am, I do.
Thank you. Go ahead.
Do you have access to any type of savings accounts in your name?
Yes, I have two different bank accounts.
Okay, where are those bank accounts?
Ready Financial and there's a credit union out of Galveston. Can't remember the exact name of it.
And about how much do you have in those accounts?
About maybe 901, and the other one was probably maybe I could, I had one of them was for withdrawals.
estimation.
Probably about 1,400 total.
Okay, and are you employed currently?
Due to my incarceration, I am no longer employed, but I do have somebody willing to take a chance on me and give me a very good job opportunity for this.
Okay, and is that job located in Jefferson County?
It would be over in Pasadena.
But
But I drive, I can
Okay.
drive back.
you would
and
be
forth.
able to come into your court settings?
I'm looking to get this settled because I cannot go on my life with this over my head.
And then do you have any type of cash or any money outside of those savings accounts that you mentioned?
I do hand over fist, fishing guide services for anybody who requests it to give me supplemental income.
But do you have any actual physical cash that is supplement to those savings accounts that you mentioned?
No, I'm not currently.
Okay. Do you have any assets, stocks, bonds, or anything like that that you could access to help make the current bond? And then do you own any real property?
Any questions?
There's
E-
no argument.
All right, go ahead, Ms. Malfino.
Judge, I would respectfully object to the bond being reduced, especially to amount of $5,000 for a habitual offender who has prior burglaries for which he has served pen time. This will be a pen time offer. In this case, I believe the offer extended by Mr. Smith actually went below the minimum 25 of his habitual status, but we don't think that any bond lower than 50,000 is justified, judge, based on his criminal history, and would ask the court to take all of that into consideration.
So I am going to take judicial note of the court's file. Need a drink? You good? Including, obviously the indictment itself that alleges, prior convictions, burglary of a habitation, second degree felony from the year 2000, two different ones from that same year, an evading arrest or detention, third degree from 2007, another burglary of a habitation, a second degree from 2018. Looks like all of those, well, we've got Galveston County, Tyler County, and Harris County, alleged, and Jefferson County. So I also have reviewed the probable cause affidavit in this case, and the allegations in this case, looks like, at least according to this, that the allegations are that Mr. Powell was actually trespass warned from the owner of the house's job, that there was some type of harassment in the past or some relationship that caused some issues where he was actually trespass warned from a job location. And that there is apparently video footage of this offense as well. Based on all of that and the fact that he would be considered a habitual offender, with this being his fourth allegation of burglary of a habitation, if anything, that bond, in my opinion, is low. Based on all of that, I'm going to deny the writ and find that, or the request of, based in that writ, and find that the current bond is sufficient, I guess. I don't really think it is, in fact, but I'm going to keep it at least the same for now. All right. and we'll reset it for an announcement. You can go back with the bailiff.
Thank you. May I be excused?
Yes, ma'am. Thank you. It was 50 or 20?
It was 50, Judge.
Okay, thank you. Ms. Minaldi, I'm also, just in case it wasn't already, I'm sure it's a condition of the bond, but I am, if you'll let him know, going to make sure if it's not a condition of that bond, that he have, obviously no contact or communication with the complaining witness, and also that he is not allowed to, live with the friend that lives across the street from her.
Okay.
Okay,
And I'll make
can't be
sure.
anywhere near the house or job.
Okay.
Okay,
Thank you.
thank
Judge.
you. And I'll make that notation on the order and you guys, it'll be filed and you'll see
Okay.
it later.
Thank you, Judge.
Right, sir, you Dalton Batiste? And this is cause number 25 DCCR 1436. Mr. Batiste is charged with manslaughter. 25 DCCR 1437 charged with manslaughter, and 24 DCCR 0407 charged with possession of marijuana. The cases are set for trial to begin with jury selection next Monday. And what is the announcement?
Couple issues, if I may, Judge. Mr. Coleman and I have talked extensively, not only this morning, but in the last lead up to today, and there has been a new proposal put in front of us that I think we'd like to ask for at least a little bit longer than today to consider. I know that also Mr. Coleman has responsibilities to focus on his side to discuss it. Or like this. Sorry.
Take a break. Why is this one's not showing up on my? What is it? It's not on my.
Actually, Angel has his trying to be a Tony. He was being very difficult. But now it says Tom Kelly, so that's why
Oh,
because I had changed their co-counsel and he was trying, I thought he was signing them out. Wanted to make him really turn.
okay.
Couldn't walk the
Sorry.
tablet.
And then
You okay? You need some water?
I've got,
you want cough drop?
Oh, I do have that.
I think the sinuses.
Yeah. Yeah.
No, it's fine. Well, okay, so here's the thing, there's only 2 defendants left on the trial docket for next week, so I need to know something today.
My other issue, Mr. Gertz asked me to say this. He is set in Judge Templeton's court on a case, Austin
Yes,
Jones.
especially
So
that-
been tried previously too.
And that's next week.
That's next week.
Yeah, I'm not sure that I should have taken that into consideration. So obviously that is a specially set case for Mr. Gertz over there. And we've done a protection order for him to get that case taken care of since it's an injury to a
I
child.
understood, Judge. I think we're very close to resolving this case. Still notwithstanding the other case, I
Okay.
still would like to try to push this case to get resolved.
Sure. So here's what
I'd
I'm
like to
gonna
talk about
do.
victims.
So what I'm gonna do is, just for a short time, take it off the trial docket, place it on a review. In about 3 weeks. That gives you and Mr. Gertz time to visit with Mr. Batiste, Mr. Coleman time to visit with. Anybody he needs to visit with, and then if something gets worked out, we'll take care of it at that time in 3 weeks. If not, it'll go right back on the trial docket and we'll go from there.
Understood.
Sound good?
Yes, Judge.
Okay, you can go back with the bailiff.
Thank you.
Yes.
Hey, Ms. Holmes, you've got Jacoby Frazier.
Yes, Your Honor. I was in the midst of signing him up, however, out of an abundance of caution, I think he needs to be
Is
evaluated.
that the one that was out here?
Yes.
Yes. So we'll reset Mr. Frazier and you can just do our order. We'll get an evaluation order today. Darius Derry. Darius Derry. Good morning. Are you Darius Derry? And will your client waive the formal reading of the indictment?
Will, Your Honor.
Mr. Derry, in cause number 26 DCCR 0234, you're charged with the state jail felony offense of burglary of a building from December 17th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Derry is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of burglary of a building. Sentence you in accordance with your agreement to a term of 100 days in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've already been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right. Good luck to you, sir. You can go back with the bailiff. Hold on. Kevin Thomas. Good morning. Are you Kevin Thomas?
Yes.
And Mr. Thomas, in cause number 26 DCCR 0798, you're charged with a 3rd-degree felony offense and assault on a security officer from March 17th of 2026. Your indictment alleges that you were previously convicted of possession of a controlled substance, a 3rd-degree felony, August 28th of 2000. And then after that was final, you were convicted of burglary of a habitation, 2nd degree, September 29th of 2008. And then after that was final, you were convicted of possession of a controlled substance, a 3rd-degree felony, March 30th of 2021. 2 cases of possession of a controlled substance on that day. And what that means, sir, is that if you go to trial in this case and you're found guilty, the range of punishment would be that of a habitual offender, which means it would be a minimum 25 years in prison up to 99 years of life. Do you understand?
Yes, ma'am.
And I have here on the tablet a plea bargain rejection that you've signed with Ms. Holmes that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, to go on, it looks like maybe count 1 and count 2 to make this a 2nd degree for a 15-year term in prison. You have every right to reject that offer. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter a plea of guilty. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
Mr. Coleman, is there any reason to believe that offer would change?
Not at all, Judge. And in full disclosure, while the 15 years is a formal offer, I did make a today only offer for less than the 15 if the defendant was amenable to that, and he's rejected that as well.
And what was that for?
I believe 10.
Yeah.
10.
So you understand if you wanted to enter a plea of guilty today, there's an offer that was extended today for 10 years. Obviously that's going to be off the table, as will be the 15 after today. Do you understand?
Yes, ma'am.
All right, so we'll get your case set on the trial docket. Mr. Thomas, Ms. Holmes has been appointed to represent you. She's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release her and we can appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you?
Yes.
All right, so Ms. Holmes, you'll be released. Mr. Thomas, we will appoint someone today. They should be out to see you very soon to begin preparation for trial. All right, you can go back with the bailiff. 0492 and 0493. Sir, are you Desirian Adams?
Yes, ma'am.
And Mr. Adams is here with Mr. Burbank. Mr. Nichols is present. We're here on a hearing with regard to motion to revoke probations in each of these cases. I see we have, I know the officers here. Are there other witnesses present? Do you anticipate other witnesses?
I don't anticipate another witnesses, Your Honor. We might have, they haven't shown up, but if they haven't shown up yet, Judge.
Okay, so I just want to make sure if either of you want to invoke the rule, if anybody's here in the courtroom that you anticipate testifying. If not, it's up to you guys.
Yeah, I'll have the probation officer probably if he doesn't call.
Sure.
I'm not gonna.
Okay. Right. Give me just,
Call her. That's fine.
give me a second to do this. All right, so Mr. Adams was placed on probation January 29th of 2018 for both charges are of deadly conduct, discharging a firearm, and he was here previously, entered pleas of true to counts 4, 6, and 8. And the motion to revoke or sorry, you guys, I thought I had these motions printed out. Just a second. And he entered those pleas of true to those counts in each of the cases, the same counts. And these are both 5-year deferred probations. And so, Mr. I got it. I'm printing it. I'm about to print one more though, if you want to wait just a second. I don't know why on this second one. I don't see the one where I made the notations on it, but. This one. That's just the original without the notations. All right. Okay, so I've received and reviewed the pre-sentence report. Have you both had an opportunity to review that report?
Yes, Your Honor, we have.
Any additions or corrections to that updated report?
Nothing to state, Your Honor. No.
Okay, in addition to that, I have received from Mr. Burbank, I think through probation, numerous letters of support. Mr. Nichols, have you had an opportunity to review those?
I have, Your Honor.
As well as a letter from Mr. Adams himself.
Yes, sir.
Right, then at this time, Mr. Nichols, you may proceed and call your first witness.
Thank you, Your Honor. State calls Adrian Ramirez.
Good afternoon, sir.
How you doing?
Please raise your right hand. You swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
Thank you, sir. You can have a seat. And if you'll just pull that microphone up as close as you can so we can all hear you. Thank
Yes,
you. You may proceed, Mr.
Thank,
Nichols.
thank you, Your Honor. Officer, would you give us your full name and spell it out for the court report?
Yes, sir. My full name is Adrian Allen Ramirez. It's gonna be spelled Adam David Robert Ida Adam Nora. Middle name is gonna be spelled Adam Lincoln Adam Nora. Last name is gonna be spelled Robert Adam Mary Ida Robert Edward Zero.
Okay, and how are you employed?
Full time with the Beaumont Police Department.
How long have you been a police officer?
Roughly 2 years.
What is your level of certification? What do you have? What kind of license do you have?
Basic peace officers license.
And is and your day-to-day job duties for Beaumont Police, is that as a patrolman?
Yes, sir.
Is there a specific area of the city that you typically patrol?
Yes, sir.
What is that?
The north end of Beaumont.
And do you have a certain time frame that you work?
Yes, sir.
What is that?
It is from 4 p.m. to 2:30 in the morning.
And did you work until 2:30 in the morning last night?
Yes. No, sir.
Did not work yesterday?
I did, but I stayed late.
How late did you end up working last night?
I don't recall. It was super late.
Later than normal.
Later than normal, yes, sir.
Thank you for being here today. And were you working in that capacity as a patrol officer for Beaumont Police back in December, specifically December 6th of 2025?
Yes, sir.
And while you were patrolling, did you come across a vehicle that caught your attention?
Yes, sir.
Do you remember what kind of vehicle it was? Do you need a copy of your report, officer?
If you don't mind.
I have it right here. And if you need to refer to it to refresh your memory, just ask and give you a chance to do that.
Yes, sir. But yes, sir, I remember the vehicle,
What kind of car got your attention?
the Buick.
And this Buick, did you observe it violate any traffic laws?
Yes,
What was that?
I can look at this, correct?
Yes, you can
if
refresh
if you
your
need to,
memory.
just ask.
Just don't read from it. Don't read out loud from it. Just read it, refresh your memory, and then answer the question.
Yes, ma'am. I remember it fell in the signal 100 feet prior when it reached Galveston and Wilson.
Okay. And based on that, did you follow and decide to pull over the Buick?
Yes, sir.
Did you immediately turn on your sirens, your lights?
No, sir.
Why not?
The reason I didn't do it is because typically when we do traffic stops, we have to call out on the license plate before we turn on the lights. And I was waiting for my Exxon license plate reader to catch the plate so I can. Typically what I do is when it catches it, I copy and paste, run it, and then I call out on it. That way I get all the viable information in case it runs.
Okay. And so when you did finally hit your flashing lights, did that Buick pull over immediately?
No, sir.
Did you do anything else to get its attention?
Yes, sir.
What did you do?
I blew my air horn multiple times and used my spotlight on the driver's side mirror to catch his attention if the lights didn't catch him.
And did that Buick keep going?
Yes, sir.
Or do you remember how many blocks?
It's about approximately 2 to 3 blocks.
Okay. And where did it finally pull over?
It finally pulled over to a private residence and Lufkin and East Lucas.
Okay. And when it stopped, did you pull in?
Yes, sir. Behind it.
And how was that vehicle occupied?
It was occupied ×3.
Somebody was driving?
Yes, sir.
And there was 2 passengers?
Yes, sir.
Now, when you pulled up, did they stay in the car or were they getting out?
They immediately got out.
Did you detain them?
Yes, sir.
And did you notice anything unusual when you first encountered these 3?
Yes, sir.
And what was that?
On a normal, I guess for lack of better words, normal traffic stop, it is common for occupants to stay inside the vehicle. If occupants get outside the vehicle, it signifies that there's something in the vehicle in there that they don't want us to see. And when they walked up to me, and even then when they opened the doors, I can smell the distinctive smell of burnt marijuana.
And you're trained to recognize that smell?
Yes, sir.
And you noticed it when you encountered the 3 individuals who got out of the car?
Yes, sir.
Did you identify the driver?
Yes, sir.
What was his name?
I'm gonna look at my piece of paper.
Certainly.
Dazirian Adams.
Okay, and the other two individuals, were they detained along with Mr. Adams?
Yes, sir.
Um, did other officers arrive and assist you?
Yes, sir.
Was one of them Officer Moss?
Yes, sir.
Is he able to be here today?
No, sir.
He's out of town, is that right?
Yes, sir.
But he assisted you with this traffic stop?
Yes, sir.
Did he begin searching the vehicle?
Yes, sir.
And while he did that, were you in close proximity to him?
Yes, sir.
And you were with the three detained individuals?
Yes, sir.
Did you observe Officer Moss retrieve several firearms from the car?
Yes, sir.
Did you observe Officer Moss retrieve some marijuana from the car?
Yes, sir.
Were you present when Officer Moss asked the individuals if there was marijuana in the car?
Yes, sir.
And then what did they reply?
They said no, they smoked it about an hour ago.
And do you remember who said that?
Yes, sir.
Was it the driver?
Yes, sir.
And the three firearms that Officer Moss took out of that Buick, where do you recall where they were in the car?
Yes, sir.
Where was that?
The back left passenger side of the vehicle.
So when you say left, the driver's side,
Yes, sir. Driver's side.
but behind the driver.
Behind the driver. Yes, sir.
Okay. Your Honor, may I approach?
Yes, sir.
Officer, I'm going to show you first. Well, do you recall what types of firearms were inside the Buick?
Yes, sir.
What were they?
Taurus, revolver, and then 2 mini Dracos.
What is a mini Draco?
It is like an AK-47, but without the stock, converted into a pistol, almost like a pistol, but chambered in rifle rounds.
I'm going to show you what I've marked as State's Exhibit 3 contained inside is a firearm. What is this?
That is one of the mini Dracos.
How do you recognize it? Did you tag this?
Yes, sir.
Do you see your name on the tag?
Yes, sir.
Do you specifically recall gathering this weapon?
Yes, sir.
So this is it's technically a pistol, isn't it?
Yes, sir.
But it's modeled after the popular AK-47 rifle.
Yes, sir.
Has no butt stock and it has a short barrel, which makes it, I believe, legally a pistol. Is that correct?
Yes, sir.
And this particular weapon, do you know what kind of round it shoots? Did you enter that on your evidence tag?
Yes, sir. May I look at it?
Certainly. You can take it. In your honor, I've had this weapon checked, cleared, and it has a gun lock.
It's chambered in 7.62.
And that is State's Exhibit 3, correct?
Yes, sir.
Show you what I've marked the State's Exhibit 4. Again, it's firearm. What is this?
It is another mini Draco.
In your honor, this weapon's also been made safe and examined by my investigators.
Thank you.
And again, this is a AK style, but without any kind of butt stock, it's technically a pistol.
Yes, sir.
And is this one chambered also in a rifle, what's commonly known as a rifle round?
Yes, sir.
Specifically 5.56 or 223, is that right?
Yes, sir.
What I've marked as State's Exhibit 5 is a handgun, a revolver, is that correct?
Yes, sir.
And this particular model is what?
May I look at it?
Certainly. Do you have it? And again, do you see your name? Did you tag and place this in evidence?
Yes, sir, I
You
did.
can take it from me.
This one is the Taurus model Judge.
And it's chambered to shoot both 45 caliber rounds and 410 shotgun shells. Is that correct?
Yes, sir.
And was this weapon loaded with 410 shotgun shells the night it was recovered?
Yes, sir, it was.
Your Honor, at this time, offered evidence States Exhibits 3, 4, and 5 and their contents. No objections as to this one.
States 3, 4, and 5 are admitted.
Officer, when you initiated your traffic stop, did your patrol unit have a forward-facing video camera?
Yes, sir.
And did it record, the traffic stop and your interaction with Mr. Adams and the other people in his car?
Yes, sir.
And, specifically, did Officer Moss have a body camera on when he, assisted you during this stop?
Yes, sir.
And it recorded his actions and what he did, while assisting you in searching the vehicle. Is that correct?
That is correct.
And have you had an opportunity to review both of those recordings?
Yes, sir.
And both your, vehicle dash cam and Officer Moss's body worn camera, did they truly and accurately record, your traffic stop and the events of that evening?
Yes, sir.
Show you what I've marked as State's Exhibit 2. It's a thumb drive, containing those recordings. Have you had a chance to review this today?
Yes, sir.
Okay. And this recording is a true and accurate copy of, Officer Moss's body cam and your dash cam. Is that correct?
Yes, sir.
You're at this time offering evidence. State's Exhibit 2. Can I take them on board now for a second?
Sure.
Good afternoon.
Good afternoon, sir.
Do you have a body cam?
Yes, sir.
Did you submit that
Yes, sir.
as part of evidence?
Yes, sir.
In reference to State's Exhibit number 2, is your body cam included on this?
No, sir.
At this time, I'm going to object to the introduction of Officer Moss's body cam, especially in light that this officer had a body cam that he said he submitted to this, and it's not part of this exhibit. I have no objections to the vehicle cam with the officer, but another officer's body cam. Your Honor, Officer Ramirez has told me he submitted a body cam. With this, it's not contained in discovery. It's not on what I have, so I don't think it's properly preserved. I've given Mr. Burbank has a copy of everything that I do have. Officer Moss's body cam, he can testify to the contents of it as he stood by and was closer than he and I are right now while all that happened. And it does offer the best evidence of the search of the vehicle.
States 2, both the car dash and the Moss body worn cam are admitted over objection.
And I'd like to publish for the court now.
Yes, sir.
Thank you. Now, Officer Ramirez, this video picks up with you behind the Buick, is that correct?
Yes, sir.
Is this turn that he's making here, is this the reason for your stop?
Yes, sir.
And it doesn't really show when he started to signal on this video, does it?
No, sir.
But your testimony is that you observed him not signal 100 feet before coming to the stop sign, is that correct?
Yes, sir.
And when does your dash camera start recording?
30 seconds before you turn the lights on.
And so this second turn that the Buick makes, they signal properly, is that correct?
May I watch it again?
Sir.
No, sir.
You don't think that's within 100 feet?
No, sir. Not from the bus stop sign to that stop sign.
Okay. But the turn that we start on in the video is the reason you pulled them over, is that right?
Yes, sir.
And during this time, your lights are not on, are they?
No, sir.
And is this what you testified, that you were entering the plate information so you could get information about this vehicle?
Yes, sir.
Okay. And so now, at this point, your lights are on and your audio starts recording. Is that correct?
Yes, sir.
And what it does, it backdates 30 seconds before you turn on your lights to start recording. Isn't that right?
Yes, sir.
That's your airphone you heard?
Yes, sir.
Holiday season at H&M. Now America's sparkling accents and bath suits
Shop now at hm.com or an HM store near you.
So you had to hit your horn again,
Yes, sir.
and they finally pulled to a stop in front of this residence. This is the corner of what, Lufkin and Lucas?
Yes, sir.
Okay, is it uncommon for people to delay pulling over when you're trying to stop them?
It is.
And that's unusual, correct?
Yes, sir.
Now they didn't try to get away. They weren't what we call evading in a motor vehicle. That's not what happened there, is it?
No, sir.
But do you believe they were intentionally delaying pulling over or fleeing while you were trying to initiate this stop?
Yes, sir.
And that in itself is a misdemeanor offense, isn't it?
Yes, sir.
Okay.
Hey, no, all three of them in front of the hood. Hey, yeah, let me handle it.
And so the driver, who's now the individual on the left, that's who you identified as Desarian Adams.
Yes, sir.
And the other two, do you recall what their names are?
No, sir.
Like, would it
Yeah, like
be
what
never-
they- May I read their names while looking at this? I know one of them, the right front passenger was Jordan Collins, and the back right passenger was Lyndon LaSalle.
At this point, had you smelled anything unusual?
Yes, sir.
Well, is that the smell of marijuana that you noticed?
The distinctive smell of burnt marijuana.
Okay. What we hear is the radio playing inside the car. Right?
Yes, sir. I didn't have time to turn it off.
I'm gonna switch to Officer Moss's body camera. And there we hear you interacting with Desarian Adams, explaining, you didn't pull over, and he's claiming what?
He's coming that he didn't see me.
Okay. And that's you, just opposite this camera, correct?
Yes, sir.
And you can hear this conversation.
Yes, sir.
They claimed it was, I believe, Mr. Collins's car. Is that correct?
I believe so.
And then Desarian Adams is the driver.
Yes, sir.
And when asked about smoking marijuana, they say, we smoked an hour ago. Is that correct?
Yes, sir.
And did Desarian Adams say an hour ago was when we last smoked?
Yes, sir.
I got this thing out there going. Thank you for the traffic stuff. Hey, we'll be done in just a minute. Go hang out up there for me. Nah, they don't talk with me. No. No, we just make sure everybody knows what happens and what else is going on their way. Hey, you're not close. Yeah. Everybody in the race, they have to be entangled. We don't take all that. No, y'all step up there. Back up, thank you. Hey, here's your first kilo. What is it? What is it? One for each of them that I found so far. I'll take those. Thanks. No, it's hard. Hey, Adrian, all of these names, and this is full of the village, okay? No. You. Well, they got one more sleep. And the other second time they continue on the street. And they all right here, get up my around guys.
And so as a result of your traffic stop and what Officer Moss discovered in the back seat, was Desarian Adams arrested for fleeing a police officer?
Yes, sir.
And was he also arrested for unlawfully carrying a weapon?
Yes, sir.
And those are both misdemeanor offenses, correct?
Yes, sir.
And specifically, as far as fleeing a police officer, essentially what he did was he refused to stop when you signaled for him to pull over. Is that correct?
Yes, sir.
And you had given him visual signals with your lights and with your high beam or with your spotlight, correct?
Yes, sir.
And auditory with your air horn several times.
Yes, sir.
And he kept driving.
Yes.
And as far as the three guns, was there the three firearms that are now in evidence, Was, did anybody claim ownership?
No, sir.
Mr. Adams claimed they are not his, they are not for me, is that correct?
Yes, sir.
And he was under the impression somebody else in the car was gonna take responsibility for it, wasn't he?
Yes, sir.
But nobody did they?
No, sir.
And those two other individuals, Mr. LaSalle and Mr. Collins, they were ultimately free to go and they left. They were not arrested, is that correct?
Yes, sir.
This intersection, of Lucas and Lufkin Street, that's in the city of Beaumont,
Yes, sir.
and is that in Jefferson County, Texas?
Yes, sir.
Is that a known address for y'all? Would you describe it as a problem address for Beaumont Police?
Are you referring back to the house where they pulled into?
To the house where they pulled in?
Yes, sir.
Multiple disturbances at that address?
Yes, sir.
Is that one reason there were so many officers that assisted you in this call?
Yes, sir.
Did any of the three that you originally detained live there?
No, sir.
And so, I'm awfully carrying a weapon usually needs some other criminal activity to go along with it. Is the fleeing the police officer the additional criminal activity that was taking place while Mr. Adams had those guns in his car or in the car he was driving?
Yes, sir.
Did it appear to you, based on what you've seen and in that video, that an attempt was made to conceal those weapons by putting jackets on top of it?
Yes, sir.
And they were found under a couple jackets, is that correct?
Yes, sir.
Thank you, officer. I will pass witness.
Thank you, Mr. Nichols. Mr. Barbe?
Yeah, sure. And good afternoon.
Good afternoon, sir.
Okay. So the beginning of the vehicle, you got behind the viewer, correct?
Yes, sir.
How long or before you saw the first left-hand turn, did you get behind that vehicle?
I don't recall.
Well, let's give an estimate. Where did you first pick the vehicle up or got behind the vehicle?
It must have been somewhere in Galveston or,
Do you know how many blocks before you saw him make the turn? Was it for a couple of blocks?
are you referring to when I first saw him?
Yeah.
It might have been a couple blocks.
Huh?
It might have been a couple blocks.
Okay,
I
so
don't
you were
remember.
following them a couple of blocks before you saw them not signal, I guess, at the proper distance, correct?
Yes, sir.
They did signal
Yes,
before
sir.
that, when we see it on the video, they did signal before that turn, right?
Yes, sir.
And you followed them a couple of blocks before that, right?
Yes, sir.
Why were you following them?
Well, it was my intention to initiate a traffic stop.
No, prior to it though, why were you following them? Because you
Oh.
were following them a couple of blocks before you saw them not supposedly.
Yes, sir.
taking the proper.
So the reason I was following them was that late at night. There's not many vehicles out driving, and I look for traffic stops to make.
So you would follow them until they made a traffic violation,
Yes, sir.
okay? Did you see any other traffic violation at that time?
Yes, sir.
Okay, what other traffic violation did you see?
They failed to make a full complete stop at the stop sign.
Well, did you write them a ticket for that?
No, sir.
Okay. And the Buick, it had dark windows, didn't it?
From what I could tell, yes, sir.
Okay. So you couldn't tell how many people were inside the vehicle, correct?
No, sir.
At the time of the stop. Agree with me?
Yes, sir.
Okay. And so they didn't speed up. They made the left-hand turn and then made another signal to make a right-hand turn. The second turn, correct?
Yes, sir.
And they didn't speed up again, right?
Yes, sir.
Correct. And so halfway down that block going to Lucas, that's when you decided to turn on your overheads to do a traffic stop.
Yes, sir.
Okay, and I'm not trying to put words in your mouth, I'm trying to recant what you said.
Yes, sir.
And when you turned on your lights and blew your horn, they didn't speed up, right?
At one point,
They tried to get away from you?
well, they stepped on their brakes multiple times and then they sped back up.
Well, stepped on their brakes because they were coming to the intersection of whatever the street before Lufkin was.
Well, in the middle of the intersection, if you see the video, they step on their brakes a couple times. Their brake lights turn on. I think twice, if I recall.
All right, did they speed up?
To me, that's speeding up.
Okay, stepping on the brakes?
No, stepping on the brakes and then they accelerate back again.
They then put their signals on again at East Lucas, right?
Yes, sir.
Okay. They stopped, put the signal on, but and they didn't stop for you, but they didn't speed off either, correct?
Yes,
Okay. And then the next block, they made another left-hand turn and pulled right in, like that's where they were headed to. I mean, they knew where they were going, right?
I believe so.
Yeah, I mean, they didn't bail out of the car. Well, let me take a step back. You've had chases, right? You've chased cars before.
Yes, sir.
Okay, failed to stop, when the people stop and they bail out of the car. Right?
Sometimes.
Okay, well, have you ever had that before?
Where they bail out?
Yeah, and run.
No, sir.
You've never had anybody run on you?
No, sir. Usually they.
Okay, well, no, stop it then. You're lucky. But they stopped at a location, right?
Yes, sir.
All right, and they got out. They didn't run, did they?
No, sir.
They came back to the car where you were standing, correct?
After being instructed to, yes, sir.
Okay, and they listened to your instructions, officer, didn't they?
Yes.
Okay, and they were cooperative, right? They didn't resist you.
Yes, sir.
I mean, the video's the video, right?
Yes, sir.
Okay, so they were cooperative. They listened to you. They didn't resist, correct?
Yes, sir.
And it appears, we don't have your body camera, but it appears you were asking Mr. Adams questions, right?
Yes, sir.
And he was answering them, was he not?
Yes, sir.
Okay. In that conversation we didn't hear between you and Mr. Adams, did you tell, because I didn't see you walk up to the vehicle at that time when you originally stopped. Did you walk up to the vehicle and leave those individuals in the front of your car?
I don't recall.
Well, if the video shows that you didn't, would you disagree with the video?
No, sir.
Okay. And so my point being is that from where you were, and it appears you were standing at your door, and they walked up from your commands, hey, come to the front of my car, right?
Yes, sir.
Okay. Are you saying that you smelled marijuana from there?
Oh, yes, sir.
Okay. What was the conversation you had with Mr. Adams originally that we didn't hear?
I don't remember.
What questions were you asking?
If I had to guess, it would have been the typical questions I always ask.
Okay. Did you ask for his driver's license?
Yes, sir.
And did he produce one?
I don't remember.
Why did you run his driver's license?
No, sir.
I thought I saw him give you something on the video.
I don't know, sir, if they watch it again, but
Did you run his name for warrant?
yes, sir, I did.
Did he have a warrant?
May I look back at my piece of paper?
Sure. Absolutely.
No, sir, he didn't have a warrant. No.
Okay. They didn't have a warrant. And he identified himself, correct?
Yes, sir.
Okay. You asked for backup because one, there were 3 individuals in the car, correct?
Yes, sir.
You didn't know what you had, but also there were people coming out of the house, correct?
At the time when I first did the stop, no, sir.
They weren't out there?
Not that I remember.
Okay. But you asked for some backup, right?
Yes, sir.
Okay. You waited until the other officer, or there were several officers, but one of the officers came to assist you, correct? I
Yes,
think that was Officer Moss.
yes,
Right?
sir.
You asked him whether or not there was marijuana in the car, correct?
Yes, sir.
But you asked whose car it was. Or was it Officer Moss?
That was Officer Moss who asked
Okay.
that.
And you come to find out that it was the front passenger of the car, correct?
Yes, sir.
Who was the owner? That was Mr. Collins. Jordan Collins? What was his name?
May I look back at
Oh,
the,
so.
I don't remember the names.
Keep it in your hand, officer.
Yeah, okay, yes, sir. Jordan Collins?
Jordan, okay, and he said it's my car. Right?
Yes,
But he was the front passenger. Right?
yes,
And then Mr. LaSalle, Lyndon, was in the rear. Correct?
yes, sir.
Okay. You don't know how or where they were coming from, or did you ask?
I don't remember.
All right, did you ever find out if they were coming from a party?
I don't remember.
Okay. Do you know whether or not any of them appeared to be intoxicated?
Yes, sir.
Which ones?
No, so you said if I remember if any were intoxicated,
Yeah,
I would remember none of them were intoxicated. from what I
none of
know.
them were intoxicated.
No, sir.
Okay. That you know of. Did you give any tests?
No, sir.
Okay. And you didn't believe that Mr. Adams was intoxicated?
I did not believe that.
No, because you would have arrested him for DWI too, right?
Yes, sir.
Okay. There was a search of the vehicle. And did you ever ascertain whose coats there were that were covering the guns?
I don't recall.
Do you know where, and I saw a packet in the video. It almost looked like a K2 packet. Was that the marijuana you said was it synthetic? Or was it regular old marijuana?
I believed it was regular marijuana.
Okay, do you know where they got that from in the car?
Yes, sir. By where the floorboard, I believe.
Okay. Now. After the fact, you ran these firearms, which were marked 2, 3, and 4, or 3, 4, and 5. Were they stolen?
No, sir.
Do you know who owned them?
No, sir.
Do you know if you ran a check to see if there was any ownership? No,
I think we can do that.
you can't run the number through law enforcement and find out.
Judge, I think the confusion is what happens when you run a trace. It shows who the initial purchaser was, not necessarily who the
So-
owner is. And it doesn't update for if there's a private sale. In the misdemeanor case, there is a trace on one of these guns that shows it was purchased by someone not connected to this case.
All right, thank
I
you.
can make that available to Mr. Burbank if he needs it.
Okay, thanks.
So you didn't run who possibly was the owner,
No, sir.
or where the origins.
No, sir.
Okay. No one claimed ownership. Right?
Yes, sir.
And from the very beginning, Mr. Adams told you, I didn't even know they were in there, correct?
I don't recall. I have to see the video.
Well, he didn't claim ownership, right? He said it wasn't mine, it was theirs. Didn't I see that in the video? You were kind of saying, come on, boys, say something.
Oh, when they said whose gun they are, and
Yeah.
nobody claimed them. Yes, sir.
All right. And he kind of looked and said, come on. Right?
Oh, I wouldn't know. That's
Well,
what
you
you
were
know.
the reason why I asked you, officer, is because you were standing right there. I mean, Mr. Nichols made the point of saying you were standing there listening to it all. But you
Right.
didn't hear that.
No, I heard that, but I'm not third person. I'm listening, sir. I can't
But
read
you
his
did hear
mind.
something about that, right? Were you the one that brought Mr. Adams down to the county
Yes, sir.
and he cooperated with you?
Yes, sir.
Didn't cause you any problems?
No, sir.
You asked him information and he provided it to you?
Yes, sir.
And did he ever say that he had marijuana, like that was his marijuana, or that those were his guns?
He did say those weren't his guns, but about the marijuana, I don't remember.
You never asked,
I don't remember.
Okay.
Happened so long ago.
but he never claimed ownership of the guns.
Yes, sir.
subject to recalling I pass the witness. Thank you, officer.
Yes, sir.
Thank you, Mr. Burbank. Anything else, Mr. Nichols?
I know, Your Honor, I'd ask that, Officer Ramirez be allowed to return. I don't think he's on duty at the moment, but.
Do you anticipate recalling him? Do you need me to have him wait around?
You working today?
No, sir.
Call.
All right, thank you, sir. You're excused.
All right, I sure appreciate it. Thank you.
Yes, sir.
Like,
Yeah, I'll get that. Thank you.
See you later. All right, sir.
You may call your next witness.
The state will call this, Joseph.
Miss Joseph, come on up, ma'am.
What began as a routine traffic stop quickly escalated into a major criminal case involving marijuana, multiple firearms, and allegations of deadly conduct. During the hearing, a Beaumont police officer testified that he first noticed a Buick commit a traffic violation by failing to properly signal before making a turn. As he attempted to initiate a traffic stop, the vehicle continued driving for several blocks, despite emergency lights, a spotlight, and repeated blasts from the patrol car's air horn. When the Buick finally stopped at a private residence, 3 occupants immediately exited the vehicle, something the officer described as unusual during a normal traffic stop. According to his testimony, he instantly detected the smell of burnt marijuana coming from both the vehicle and the occupants. The driver was identified as Dazzy Adams, and additional officers arrived to assist. During a search of the vehicle, police reportedly discovered marijuana along with 3 firearms hidden behind the driver's seat. 2 of the weapons were mini Draco pistols, AK-style firearms chambered in rifle-caliber rounds, while the third was a Taurus revolver capable of firing both .45 caliber ammunition and .410 shotgun shells. Prosecutors emphasized the serious nature of the weapons recovered, while officers testified that all 3 occupants initially denied having marijuana in the vehicle before later admitting they had smoked earlier in the evening. Throughout the hearing, evidence including firearms, dash camera footage, and body camera recordings was presented to support the state's case. As the proceedings continued, defense attorneys challenged portions of the evidence, particularly questions surrounding video recordings and body camera footage. They argued that not every recording collected during the investigation had been properly preserved or included in discovery. Prosecutors countered that the available footage accurately documented the traffic stop and search and provided some of the strongest evidence in the case. The judge ultimately allowed the recordings into evidence, permitting the state to continue presenting its case. What makes this case particularly significant is that the defendant was already facing allegations related to deadly conduct involving the discharge of a firearm and was appearing before the court after previously entering pleas